Okay, so we'll make a start. So welcome everybody. This is the latest in a series of data protection related webinars that we've been running. Could I ask first that you all mute your microphones just to avoid sound problems. The webinar is being recorded. We will send all of you a link to the recording after we've finished, and it will also be available on our website as well. So if any of you would like to rewatch all or part of it, it'll be available. There are three of us speaking today. We're all members of the data protection team. I'm up first. I'm a consultant lawyer with the firm, and I'll be doing a bit of a scene setting exercise in relation to the Brexit and data protection generally. Following me, Hannah Pettit, who is a solicitor in the firm, will talk in more detail about the UK adequacy decision, which we hope will be forthcoming. And after Hannah, Charlotte Kingman, who is an associate in the team, will tell us more about international data transfers following Brexit. So the broad topics are all on that slide available now. So moving on to the next slide, what is the UK data protection law position following Brexit? Next one, please. So where are we now? The UK left the European Union on the 31st of January 2020, and the transition period, which was agreed as part of the leaving arrangements, ended on the 31st of December 2020. So what effect did that have on data protection law? Well, first, the UK became a third country so far as the European Union is concerned. The UK is no longer subject to GDPR, and UK law is made up primarily of the Data Protection Act 2018, which remains in force, and also retained regulation EU 2016/679, known now as UK GDPR. As matters stand at the moment, UK GDPR is very similar to the GDPR. In future, though, as time passes, it is entirely possible that UK and EU law will diverge in relation to data protection. So whilst the law is similar at the moment, that may not be the case as things move on. So next slide, please. So what are the effects of that change in status so far as the UK is concerned? What about transfers of data out of the EEA to the UK? Well, the deal that was done just before Christmas provided for a grace period which will last until the 30th of June 2021. And what the grace period means is that for the time being, data transfers can continue as they did before, as if the UK remained within the EU. What happens after the 30th of June depends on this adequacy decision point, which basically is whether the EU decides that UK law is adequate in relation to its data protection safeguards to permit flow of data from the EEA without any further documentation being required. If the European Commission does grant the UK an adequacy decision, then data can flow just as it does now. If the Commission doesn't, and Hannah will talk in more detail about this a bit later on, then data will only be able to flow from the EEA to the UK if other safeguards are in place, and the most common safeguards will need to be what are known as standard contractual clauses. And Charlotte will talk about those in a lot more detail later on. So far as transfers from the UK to the EEA is concerned, well, the UK regards EU law as adequate. Data transfers from the UK to the EEA can continue as before. Beyond the EEA, again, there's no practical change because UK law, as things stand at the moment, is similar to EU law. So UK data can transfer to countries beyond the EEA as long as those countries have adequate data protection regimes in place. And if they don't, those transfers need to happen on the basis of UK standard contractual clauses. And we'll hear more about those from Charlotte. So what are the practical implications of all that now? Well, the obvious one is current documentation, privacy policies and notices, employee data protection material, supply agreements, other commercial agreements, any materials that contain data protection related content are going to need to be reviewed in the light of the new world that we're in. They're all going to need to be reviewed and updated as required. And the best time to do that is as soon as possible, really, and particularly having regard to the fact that we've only got about 3 months of that grace period left. So let's move on to Hannah now, who will tell us more about the latest position on the adequacy decision for the UK.
Thank you, Tom. So I'm Hannah. I'm a solicitor in the Commercial and Data Protection team at Ashfords, and I'm going to be having a little look at the current progress of the UK adequacy decision procedure, as well as the likelihood of us having achieved an adequacy decision by the end of the bridging period.
What's up?
Oh, could I just double check that everybody's got their microphones on mute, just so that we don't have any background noise? Thank you. So Tom has already helpfully set out the grace period. So that was granted to us under the Trade and Cooperation Agreement. And that allows the continued free flow of data from the EU into the UK after that transition period ended for a period of up to 6 months. Next slide, please, Charlotte. So it was first announced at the end of December that we would benefit from this grace period, also commonly known as the bridging period, to allow personal data to continue to flow from the EU into the UK. And at that same point, it was also declared that the European Commission would formally commence its adequacy decision process for the UK. So I think the fact that these two things were announced at the same time did give us quite a lot of hope that the bridging period was sort of a holding period to avoid any interruption and then allow us to achieve that adequacy decision before the bridging period had expired. But we're now halfway through that bridging period, if it extends for the full 6 months until the 30th of June. So I think it's probably a useful time for us to stop and have a look at how the adequacy process has progressed already. So you've got 4 key stages for the adequacy decision, and you've got a large number of parties that are involved along the way. So to begin with, the European Commission prepares a proposal, and this is in the form of a draft adequacy decision. Once that draft decision's been published, it is submitted to the European Data Protection Board, the EDPB, and they will review the draft decision and they then prepare an opinion on it. Once that opinion has been prepared, the European Commission then reconsider the draft decision in light of the opinion. And after that has been completed, they will submit the draft decisions to a committee of representatives from different EU member states. So that ensures that across the EU you've got representative views, and they will then vote on whether they approve that decision. If it is approved, the final step is then the formal adoption of the decision by the European Commission. So it's quite a circular process. It starts and ends with the European Commission, and that's after the relevant parties have approved it. Now, on the 19th of February, the European Commission published 2 draft decisions for the UK. So that's under the first stage there. Next slide, please, Charlotte. So we've got 2 draft decisions for the UK, the first of those being under the EU GDPR. And this one is relevant for private companies. So it allows private companies within the EU to continue transferring personal data into the UK. You've then got the second draft decision, which is under the Law Enforcement Directive. And this allows EU law enforcement agencies to continue transferring personal data to their counterparts in the UK, so UK law enforcement agencies. And this is really good news because those draft decisions confirm that the data protection regime in the UK is equivalent to the data protection regime in the EU. And it means that we've completed step 1 of 4 on that previous slide. So we're making good progress. It means that those draft decisions are now with the EDPB for their opinion. So that was stage 2 on the previous slide. Now, it seems like a logical conclusion that the UK will have been considered to have an equivalent level of protection to the EU, as we've only just left the EU. And as Tom explained, the UK GDPR is essentially the same as the EU GDPR, with just a few updates so that it works within domestic legislation. So it definitely makes sense that we would be given that rating as equivalent. But why then have the European Commission had some concerns? Next slide, please, Charlotte. One of the key concerns has arisen from the fact that the UK now has the freedom to depart from those EU GDPR standards in the future. And I think ultimately this is a key reason why those draft adequacy decisions have in fact been limited in duration. So they've been limited in duration to 4 years, and after that 4-year point, they aren't going to automatically renew. At that point, the UK would have to demonstrate again that it does have an adequate level of protection, and it does sort of deserve that adequacy rating to be continued. Now, with any country that has obtained an adequacy decision, so to give you a few examples of other countries that have achieved this, we've got Argentina, Japan, Israel are other examples. There is always a risk that the regimes in those countries is going to change from the position when the adequacy decision was granted. So the EU is always regularly reviewing the regime in those countries, and it's making sure that the standards don't degrade from the standards as were when the decision is granted. But that said, the UK decisions are the first that have been limited in duration. I think that's really quite a poignant point, because I think that shows that the European Commission does have particular concerns about whether or not the UK regime will depart from the EU regime in the near future. And I don't think this is out of the question either. So to give you a bit of background, the ICO, the Supervisory Authority for Data Protection Matters in the UK, that's headed up by the Information Commissioner. And at the moment, that's Elizabeth Denham. And this year, Elizabeth Denham as the Information Commissioner is due to be replaced as she reaches the end of her 5-year term in the role. And I think it's going to be really interesting to have a look and see what direction data protection legislation takes in the UK under her successor. And just to be clear, the Information Commissioner and the ICO, they don't have the powers to legislate, so they wouldn't be able to create new data protection legislation. But a new Information Commissioner would have different priorities, different strategies. And I think for this reason, there is definite scope for a change in Information Commissioner to, show a bit of a shift in the data protection regime in the UK. And if there were ever to be new data protection legislation to be tabled within the UK in the future, the Information Commissioner would have a really central role in consultations for that. So definitely a case of watch this space. And with this in mind, I think the key question then is, what is the likelihood of us obtaining this adequacy decision before the end of that bridging period expiring on the 30th of June? So prior to those 2 draft decisions being published on the 19th of February, one of the key hurdles and a lot of criticism was focused around the surveillance powers of UK authorities. And there was a lot of concern that these surveillance powers were what was preventing us from having an adequate level of protection for personal data. Now, those draft decisions that the European Commission published address this in 2 ways. So firstly, they conclude that the national security exemption under the Data Protection Act goes no further than what is necessary and proportionate. So that was, a really useful finding. And secondly, they also confirmed that the Information Commissioner and the ICO has got sufficient independence and sufficient power to enforce privacy protection within the UK. So, for example, if there was a complaint that was lodged with the ICO would in fact have the power to investigate and to make a finding as to whether the national security exemption under the Data Protection Act had been appropriately applied. And in my view, I think this independence has been a real comfort for the European Commission, and that is a key reason why they have been able to publish these draft adequacy decisions which confirm that there is an adequate level of protection for personal data within the UK. And as a result, I think this shows one of the key obstacles that a lot of the criticism was focused on has now been overcome. And this, in my view, means that the outcome of a final approved adequacy decision is looking a lot more promising than it did do prior to the 19th of February. But that said, we have only now completed step 1 of those 4 stages that I previously set out. So we've got 3 more of those to go. And I think for that reason, it's still really unclear whether we are going to reach an approved adequacy decision by the end of the bridging period on the 30th of June. And one of the key risks that to be aware of here is that there is still objection and challenge from privacy campaigners. And that's going to really influence the EU member state representatives when they vote on the decision at stage 3. So if they're aware that the decision is being challenged by those campaigners, they may be less likely to approve it. And even if it is approved and we achieve the decision, there's nothing to say that those privacy campaigners wouldn't then challenge it after the event. And this is what we saw quite recently with the EU to US Privacy Shield challenge. And that was challenged in the Schrems case. So definitely something to be aware of, that even if we obtain this adequacy decision now, there's nothing to say it could be revoked quite quickly. So to conclude then, it's definitely good news that we've had these draft adequacy decisions published, definitely very promising. But I don't think that the UK are through the woods yet. And I think companies really do need to be alive to the risk that we may not achieve this adequacy decision by the end of the bridging period. And it would be really prudent to make sure that you've got adequate safeguards in place now, so there isn't any interruption to your data flows where you are receiving or transferring data from the EU into the UK. And that leads on nicely to our final topic, which Charlotte's covering, and that's looking in a bit more detail at these safeguards and in particular at the model clauses.
Thanks, Hannah. Good afternoon, everyone. I'm Charlotte Kingman. I'm an associate in the Commercial and Data Protection team, and I'm going to be discussing international transfers using standard contractual clauses, particularly focusing on the context of EU transfers post-Brexit. So what are standard contractual clauses? So SCCs, or commonly referred to as the model clauses, are one of the legally binding transfer mechanisms that you can use in order to transfer data globally. There are other mechanisms that you can rely on. So this is things like binding corporate rules. And obviously, as Hannah's already talked about in detail, countries that receive an adequacy decision don't need to have things like SCCs in place. The SCCs can be incorporated into a wider commercial contract with your other commercial factors such as fees, etc., or they can be signed separately as a standalone agreement. And you will often see them, if they are signed as a standalone agreement, refer out to the commercial contracts or to, for example, data protection addendums. The SCCs themselves place legally binding obligations on the company transferring the data, so that being the data exporter, and the company receiving the data being the data importer. And data subjects, so the individuals whose data you're actually transferring, do have rights to enforce the obligations against either party. So currently the SCCs are non-negotiable. You cannot make changes to the main content of the agreement. They are issued by the European Commission, and if they are amended, then they wouldn't necessarily be enforceable. You are, however, now permitted in the UK to make changes to the EU SCCs so that they can work in a UK context. What this means in practice is, because post-Brexit the UK is still using the EU adopted SCCs, we can change references to the European legislation to refer to things like the UK GDPR or the Information Commissioner's Office as our regulatory body in the UK. The other amendments that you can make are normally in the annex, and they are to include the processing details or the security measures that you are adopting specifically for the particular arrangement. And as I've already mentioned, you will see SCCs that are put in place where you do refer out to possibly other documents such as DPAs. Currently, there are two sets of standard contractual clauses. There are controller to controller clauses and controller to processor clauses. It's been widely scrutinised and widely recognised by the European Commission that the current SCCs do not reflect the complexity of processing chains in this day and age, particularly where you've got multiple parties and particularly where you've got multiple sub-processors involved in the processing chains. So how has Brexit impacted transfers? So previously, we didn't need to worry about transfer mechanisms and SCCs between the UK and the EU, as they were both governed by the same regime, and such transfers weren't considered to be restricted for the purposes of the GDPR. EU SCCs entered into before the 31st of December, so that's before the end of the transition period, still stand and are valid. So what this means in practice is if, as a UK company, you have put SCCs in place with other companies that you are working with under the EU SCCs, they are still valid and you can still continue to rely on them. From the 1st of January 21, the same applies. So if you have put SCCs in place from the 1st of January, at the moment, those SCCs are still valid and you can still rely on them. You'll also find that post-January, we're seeing a lot of companies from the EU insist that they put model clauses in place between the EU company and the UK company receiving the data, and that's almost in anticipation of us not receiving an adequacy decision as a safeguard to make sure that they are future-proofing. As Hannah's already mentioned, whether or not we receive an adequacy decision will have a key impact on how we use model clauses going forward, and of course whether or not we actually need to implement model clauses between data being transferred from the EU to the UK. As Hannah also mentioned, whether or not we receive an adequacy decision is not a one-stop shop. So if we do achieve it and we are granted an adequacy decision in June, then we don't need to just park it and never think about it ever again. We do need to make sure that we're continually staying up to date because, as Hannah mentioned, the UK could lose that decision if later down the line it decided to depart from the regime, from the GDPR regime. So UK and EU SCCs, so what's the difference and what's changed? Well, post-Brexit, we are no longer required to adopt the EU standard contractual clauses. So post-Brexit, the ICO and the Secretary of State now have the power to issue SCCs specifically for the UK. It's therefore important, I think, to start thinking about these as quite distinct. So at the moment, we are still using the EU SCCs, but that's not necessarily going to be the case going forwards. However, as part of the bridging arrangements, we know that the UK won't adopt new SCCs until we know whether or not we've received an adequacy decision, and it will then be up to the ICO and the Secretary of State as to whether or not to adopt those EU SCCs, whether that's the current version or an updated version. The ICO has stated as well that they are keeping these transitional arrangements under review, and they have stated on their website that they intend to consult on and publish potentially new SCCs for the UK during 2021. So this is a particular area that is key to keep an eye on if you are a company that is involved in data transfers globally and particularly within the EU. So you may or may not be aware that the EU Commission issued draft model clauses in December 2020, and this was with a view to implementing and updating new standard contractual clauses for data transfers outside of Europe. They released the updated SCCs, as I said, in December. They've not yet been adopted. If they are adopted, it will mean that they are not valid as SCCs for stricter transfers from the UK, unless the UK decides to also adopt them. They have been updated to try and better reflect the complexity of processing arrangements at the moment and that a lot of companies will see in their processing chains. As I mentioned earlier, this is to account for things like multiple parties involved and complicated processing chains where you have a number of sub-processors, for example. Well, once implemented, the old SCCs that we're currently using can no longer be used, and the organisations will have 1 year to implement the new SCCs. So what are the key changes under the new draft SCCs? So the first key change is that they are separated into modules. What this means is you have specific arrangements covering controller to controller arrangements, controller to processor arrangements, processor to processor arrangements, and processor to controller arrangements. This differs from the current versions, which only cater for controller to processor and controller to controller. So the final option, processor to controller, refers to a situation where you have a non-EU controller, which would now include a UK company, appointing an EU processor to process data, where that EU processor transfers information or data back to the non-EU controller. So taking the UK as an example, this would be as a UK company, you appoint a European processor, you send them data to the EU, and they send it back to you. And that would be an arrangement that's not currently governed or catered for in the current draft that we normally use. The new SECs also contain what we call a docking clause. This allows third parties to subsequently sign up to and agree to the SECs after the initial entry into them by the original parties. So in theory, this is quite a helpful mechanism that could be used to expand the processing arrangements as they build and get more complex potentially as the relationship develops. So this may be an example where you have controllers and processors that appoint sub-processors to provide parts of the services. Under that arrangement, they could, in theory, sign up to the SECs that had already been entered into between the controller and the processor. The new SECs also impose an express obligation on non-EU controllers to notify EEA authorities about any data breaches. So this is a new reporting obligation. So this does apply irrespective of whether the GDPR actually applies to that controller or not. Again, this is particularly relevant for UK organisations receiving data from the EEA. So you'd not only potentially need to notify the ICO depending on the breach, but you then may need to consider whether or not you need to notify the regulatory body in the member state as well. I think this is something that could become particularly relevant during the commercial negotiations, where you are looking at things like timeframes of notification, for example, within your processing chain, particularly where the transfers can be high risk. In a processor-to-processor scenario, the controller's audit rights also are flowed down to the processing chain under the new SECs. So this means that any sub-processor in that chain can be audited by the ultimate controller. Again, this is quite a shift in the position. And whilst this might be a welcome change for controllers, as ultimately it would give them the opportunity to have more oversight and closely monitor their processing chains, it may cause some difficulty for sub-processors where there may be no commercial contractual link between that sub-processor and that controller. So there may be a situation where the standard contractual clauses are the only contractual link between them, and then they don't have the opportunity to put in safeguards and parameters potentially around that audit right, such as allocating costs, etc. The Schrems II decision also continues to apply when you're making restricted transfers from the UK using SECs. This decision requires that you must make an adequate assessment as to whether or not the SECs provide the protection that is essentially equivalent to the UK regime. And this is particularly important and has really, the Schrems case last year really put light on the security measures that companies are adopting and the actual practical steps that they're taking to protect that information. I would expect going forward that controllers, particularly EU controllers, will take a more stringent approach to this during negotiations, and they will be expecting processors and sub-processors to be clearly demonstrating the steps that they are going to take in terms of protecting that data. So the ICO's conclusion at the moment is, and advice to UK organisations, is to review your international transfers and just try and stay up to date with the guidance and the advice as it becomes available. Our recommendation is undertake a data mapping exercise. What this means is, understand as a business where your data flows are and what your processing chains look like. Make sure you've got a good understanding of where the data is flowing and how and to what countries. Hopefully this will put you in good stead, not just to decide whether or not you need to take action in June if we receive an adequacy decision or not, but also later in the year if either the UK adopt new standard contractual clauses or we decide to adopt the EU draft standard contractual clauses, again, if they're adopted by the European Commission. Thanks very much for joining us today. It's really nice to see some familiar faces, but also some new ones. Please do feel free to get in touch with any of us directly if you have any questions or would like more information on the topics that we've talked about.